before we start, don't forget to check out our official shop at shopq2cast.com, where you can get an additional 15% off your purchase for a limited time only. Use the promo code TREAT15 at checkout. Proceeds goes to help independent content here on Q2Cast TV. That's shopq2cast.com. The promo code is TREAT15. And thank you. Okay, let's get this off to the side. First of all, one, I am not a lawyer. I'm a person who looks at articles and comments on them, some of them having some legal aspects to them. Also, I am not a copyright attorney or 100% knows about, I've dealt with copyright, but not to the point where basically I understand all of the copyright law, because it's the laws keep changing and gets more confusing. And I hope Nick Rekieta picks this up, or any of the other lawyers on YouTube picks this up, because I think this is very important and it's happening again. So that's out of the way. I have to laugh because basically I think Marvel, well, not as much as Sony, but Marvel and Disney are getting slammed in every direction possible from creators. We already have heard the Predator, the Muppet Babies, a couple of other iconic characters that basically some of the creators want their control back. We've heard this from the DC universe, the Siegel lawsuits, as far as, for Superman comics and film rights. So now this has come forward just within a couple of days ago. And we'll read a little bit from Bounding into Comics on there. Spencer wrote this on there. A recent legal move by the estate of Spiderman and Doctor Strange co-creator Steve Ditko could result in Marvel losing their respective copyrights over the Web Slinger and the Sorcerer Supreme. According to the two respective notices of terminations filed with the United States Copyright Office on August 26 and brought to widespread attention by Marvel artist J.L. Mass, Patrick Ditko, brother of Steve Ditko and the current administrator of the late artist's estate, is seeking to revoke Marvel's copyright over Amazing Fantasy Volume 1, number 15 stories, Spider-Man, which is the Wallcrawler's first appearance, and Strange Tales Volume 1, number 110, the debut of Doctor Strange in the appropriate title, Doctor Strange, Master of Black Magic. If successful, Patrick Ditko's termination of Marvel's copyrights would not necessarily require the publisher to stop publishing the comics featuring the characters, as they would retain the trademarks over them, but could see them barred from using any of the elements featured in the two stories. Thus, items such as Spider-Man's web shooters or the Amulet of Agamotto, characters including Aunt May, Uncle Ben, Wong, and the Ancient One, or even both heroes' costumes could not be used by Marvel in any comic, film, or other media. Whoops. The logistics of copyright termination law are, to say the least, complicated, as noted as Robinson, Bradshaw, and Hinson, attorneys John Connolly and Nicole Levy, in an article written in Legal to the historical legal battle between the Siegel estate and DC Comics regarding the copyright of Superman. The basic rule for the works created and assigned prior to 1978 is that the termination can be effective at any time within a 5-year window that opens up exactly 56 years from the date of the copyright was originally secured, the pair explained. As if Siegel, a copyright was secured in 1938, the 5-year termination window opened up in 1994, but even if that window is missed, even if the work was in its renewal term in 1998, a second 5-year window opens up 75 years after the date of copyright. Schuster's heirs are seeking to take advantage of this provision, having given notice to intent to terminate in 2013. They continued, if the first work is created or assigned after 78, the termination can generally be effective anytime during a 5-year window beginning 35 years after the executed of the grant. Taking these legal provisions into account, the window to terminate the copyright over the Spider-Man's initial publications in 62 would open in 2018 and would end in 2023, while Doctor Strange in 63 introduction will make his copyright eligible for termination between 2019 and 2024. So there's a lot more into this, and you could say to yourself, well, what does that mean? You know, could Disney lose the rights to the Marvel films? Could Sony lose the rights? Yes and no in certain cases. If they lose this battle, they would have to deal with the DITKO Estate if they want to move forward with any future endeavors of Spider-Man or Doctor Strange in the Marvel Universe. And the same thing with Sony if they want to move forward with anything dealing with Spider-Man. Now, in a way, you could say it's a good thing that this is happening. But the thing about it is, this could be tied up in court for a long time. And the thing about it is, you have to understand, this also comes to the point that Disney is involved. And Disney is notorious, and I'll say this, they're notorious at winning these copyright cases because basically they lobby to change the laws. This is the reason why Mickey Mouse is not in public domain. Could you imagine, could you think about this, foresee that Mickey Mouse gets put into a point where basically anybody, any company, anyone, you, me, anyone could pick up Mickey Mouse and create a cartoon, create a series, novels, comic books, anything on the character itself, and put it out and make money from it. Think about that. That's what public domain is. This is why a lot of companies don't want their products in public domain. Because basically they lose the rights. If you look to the perspective, how many vampire films or Dracula films, Frankenstein, Wolfman, Mummy films that have been through the last decade or two? Think about that for a minute. Why is that? You know, the original novels to these stories and movies that we see constantly is in public domain. Anyone can use it. It's the same thing with, I believe Sherlock Holmes is in that situation. Of course, a lot of the stories like Little Red Riding Hood and Cinderella, Aladdin, that's why you see Disney grabbing up these stories and remaking them and doing a horrible job at them now because they're just taking the older ones and remaking them. And put it this way, Amazon just did Cinderella. A perfect example. How horrible was Cinderella? Really, truly, it's horrendous. And the thing about it is, most of these people have made these stories they sort of remodernize, which we don't like that word, these stories for the modern era. And technically, like stories like Cinderella and Pinocchio, Little Red Riding Hood, end horribly. They end very horribly. You know, Pinocchio kills Jiminy Cricket. Do you understand it? He kills him with a shoe. And Pinocchio gets hung on a tree outside at one point. I think that's the end of the story, if I'm not mistaken on that. Little Mermaid cuts her tongue and she dies. She dies of loneliness. I think she commits suicide, if I'm not mistaken. I think, what is it? The evil queen in either Cinderella or is it Snow White or something? They put like shoes on her. They burn her feet and stuff like it. It's horrifying tales. Let's put it this way. They're very horrifying endings to all these stories. But yet, companies like Disney come along, take advantage of the copyright regulations, and public domain regulations and start making these stories. Not saying the original Cinderella was a bad story, not saying the original Snow White, Pinocchio, Sleeping Beauty, all that. But you could see what Disney has done in the past and then what they're doing currently now. They won't let go a lot of these products. They won't let go of the content that they are putting out. And they will fight for it. Right now, they're still fighting the Predator fight. That fight is still going on. Right now, they won the Muppet Babies one temporarily. I don't know if he's going to refile or anything of that nature. I would assume he's going to, concerning the way the Muppet Babies are being treated in this new era for that series, and the way Muppet Baby, well, the Muppets are, it's pure crap that they've done. They don't know, Disney doesn't know what to do with them. But could you really imagine if Disney loses the entire rights to Spider-Man and Doctor Strange? How could the MCU go forward? What would they do going forward if they don't have Doctor Strange or Spider-Man in their roster? This could hurt. This could really hurt them. This could really hurt. They would have to go back and whatever plans that they have, redo them, or the worst case scenario, which we know that it's already going to be woke. They're going to rush now these movies as much as they just rushed the new Predator movie, because basically there were articles to cease to temporarily shut down the production until the legal aspect was completed. But they rushed through it and completed the movie anyway. Goes to show how good that movie probably will end up. So we'll have to look at this. Hopefully, like I said, Nick Rekieta picks this up, or any of the other lawyers, Viva Fry, or any of the other lawyers that's on YouTube, and to see what will happen next as far as this lawsuit. So we've reached this part of the video. Thank you for tuning in. Don't forget to hit that like, subscribe, share. Don't forget to check out Saturday Pre-Flight every Friday, 10 p.m. Eastern, 7 Pacific, on your local social media platforms, BitChute, YouTube, and later on Odyssey. So we'll see you next time. Bye-bye now.